A reporter at ABC6 in Columbus opened her laptop last night and clicked a link the jail had sent her, a Google Drive folder, the intake video of Gary Siders Jr. from the Southeastern Ohio Regional Jail. She could see the file name. She could see the thumbnail. She clicked play, and the screen went black. Access denied. The link the jail had handed over that same morning was dead by evening. Somebody somewhere had reached in and pulled the plug. That is where this story starts today. Not with the raid, not with the kids, with a file that existed for a few hours and then didn't. Because right now, in Vinton County, Ohio, a gag order signed on July 14th is being used in a way its own writer probably never planned. Judge Laina Fetherolf Rogers signed that order to protect the case, to keep the jury pool clean, to make sure the defendants got a fair trial. That's the legal language. That's the reason on paper. But look at what has actually happened in the last 48 hours. And you start to see a very different picture. The jail released visitor logs, real names, real dates, real times. Those logs show that people from Children's Services visited the defendants inside the Southeastern Ohio Regional Jail. That is public now. That is out there. Anyone can read those names. But the intake video, the booking footage, the one thing that would show you with your own eyes what Gary Siders Jr. looked like when he first walked into that jail, gone, pulled, access revoked. And when ABC6 asked why, the jail's own attorney would not answer. He pointed at the gag order and closed the door. So here is the pattern. Visitor logs, yes. Booking video, no. Names of Children's Services workers, yes. The face of the defendant on his worst day, no. That is not a gag order protecting a defendant. That is a gag order picking and choosing. And when a gag order picks and chooses, somebody is choosing for it. That's when Ron O'Brien picked up the phone. If that name doesn't mean anything to you yet, it will in a minute. Ron O'Brien was the Franklin County prosecutor for 24 straight years, from 1997 to 2021. 24 years. He prosecuted more homicides, more child endangerment cases, more felonies than almost any lawyer alive in Ohio today. When he talks about how a case should be run, other prosecutors listen. When he talks about how a case is being run wrong, judges get uncomfortable. Ron O'Brien went on the record this week and said, in plain words, that the Vinton County gag order was overbroad. That is the legal word. In plain English, it means the order sweeps up too much. It gags too many people. It hides too much. It goes further than the law allows. But that wasn't even his biggest hit. His biggest hit was this. He said the order was issued without notice, without a hearing. Stop and think about what that means. In American courts, when a judge is about to sign an order that shuts people up, reporters, witnesses, family members, anybody, the law says you have to give everyone a chance to show up and argue. You have to hold a hearing. You have to put the reasons on the record. That is not a nice to have. That is not a formality. That is the whole point. Because gag orders touch the First Amendment. They touch free speech. And you don't sign away free speech in the dark. According to Ron O'Brien, that is exactly what happened in Vinton County. The order got signed, the order took effect, and the people it silenced were never in the room. The Columbus Dispatch is now suing. That's Gannett. That's one of the biggest newspaper companies in the country. Their lawyer is a man named Jack Greiner. Jack Greiner has been fighting First Amendment cases in Ohio for decades. He is not a random attorney off the street. When Gannett hires him, it means they plan to win. And what he is arguing in court paperwork filed this week is simple. The public has a right to know what happened inside the house on Omer Street. The public has a right to see the booking video. The public has a right to hear the courtroom testimony. Sealing all of it without a hearing, without evidence, violates the Constitution. So now you have a fight. On one side, a judge in a small county trying to protect a case she says is fragile. On the other side, a former prosecutor with 24 years on the job, a national newspaper chain, a Columbus TV station, and a First Amendment lawyer with a career of wins behind him. This is not going to be a quiet fight. And here is where the ordinary viewer, the person at home watching the news, should stop and pay attention. Because the way this fight plays out will decide something bigger than one case. It will decide how much you, as a citizen, are allowed to know about the people who allegedly hurt children in your own state. Let me put it another way. If a judge can shut off the flow of information without a hearing in the biggest child abuse case Ohio has seen in years, then a judge can do it in any case. The next one, the one after that. Every single time a story like this makes the news, the door can just quietly close. And you will never know what was behind it. That is what Ron O'Brien is saying, even when he doesn't say it that way. He is saying, we don't do this in America. We hold hearings. We put reasons on the record. We let the press in. And when we don't, something has gone wrong. Now let's talk about the Children's Services visits, because this is where the story gets really strange. The visitor logs the jail release show that Children's Services workers went to see the defendants inside the jail. That's a red flag right there. Children's Services doesn't usually visit adult defendants in county lockup for a friendly hello. Something was being discussed, some question was being asked, and whatever was being asked, it was important enough that a state agency sent employees behind those bars to have the conversation in person. And yet, the jail is telling reporters we can release the visitor logs, but we cannot release the intake video. Think about that. The names of state employees given to the public, the face of the accused hidden from the public. If the goal was to protect the fairness of the trial, wouldn't it be the other way around? Wouldn't you protect the state employees from being harassed and let the defendant's booking video, which was created by the jail itself as a routine business record, go out? Something is upside down, and Ron O'Brien noticed, and Jack Greiner noticed, and the reporters at ABC6 noticed, and that is why this story is not going away. There is also a very human piece to all of this. Behind every legal fight, there are people making phone calls at 10 at night, wondering what they are allowed to say. There are relatives of the 16 children who don't know what they can tell a reporter without breaking a court order they never signed. There are neighbors on Omer Street who saw things back in May and June and have been sitting on that information ever since, afraid a judge might come down on them. That is what a broad gag order does. It doesn't just silence lawyers. It ripples out. It silences a whole town. And in a case where a town was already too silent, where 16 children lived in one small room and nobody outside the family seems to have knocked on the door, that ripple of silence is exactly what you don't want. Here is where the story sits today. The Columbus Dispatch lawsuit is moving. Jack Greiner is asking for an emergency hearing. Ron O'Brien is likely to be called as an expert. Judge Rogers has not backed down. And the intake video of Gary Siders Jr., a routine piece of jailhouse footage that in almost any other case would be on the internet by now, sits on a hard drive somebody has decided you do not get to see. Ask yourself why. Ask yourself who benefits when the booking video of a man accused of the worst kind of neglect stays hidden while the names of the social workers who visited him are handed out. Ask yourself which side of that trade helps protect the 16 children. Because from where I'm sitting, one of those two answers helps the children and the other one helps the defendant. And it is not the answer the jail has picked. There is one more thing worth saying, and it's uncomfortable, but it matters. When a judge signs an order without notice and without a hearing, and then a former prosecutor with a spotless record goes on television and says that is not how we do it, you have two possibilities. Either the former prosecutor is wrong, or the judge cut a corner in the biggest case of her career. In America, both possibilities are allowed to be argued. That is why we have appeals. That is why we have hearings. That is why we have a free press, so they can be argued in the open, in front of everyone, in a courtroom where the reasons go on the record. That is what is missing right now in Vinton County. The reasons on the record. Ron O'Brien has said as much on camera this week. Jack Greiner is putting it in writing in a lawsuit this week. And the intake video of Gary Siders Jr. is sitting on a jail server somewhere this week, and nobody in that jail is willing to say out loud who deleted the link. If a grand jury sits down in a few weeks to look at this case, they will only see what the state hands them. They will not see the Google Drive that existed for a few hours. They will not see the emails. They will not see whatever pressure was applied to make that link go dark. That is the piece of the picture that has already been cut out. And when Ron O'Brien says the rules weren't followed, that is what he means. Not that a judge made a mistake, that a piece of the truth was walked out of the building. We are going to keep watching the Columbus Dispatch lawsuit. We are going to keep watching Judge Rogers' docket. We are going to keep watching every single time the Southeastern Ohio Regional Jail releases something, and every single time they hold something back. Because the pattern is what tells you the story. And the pattern in the last 2 days tells you that somebody has decided what you, at home, on your couch, are allowed to know. That decision was not made by you. That decision was not made by a jury. That decision was made in a courtroom, without a hearing, without notice, on a piece of paper signed on July 14th. And a 24-year prosecutor just stood up and said, that is not how we do this. Now the fight is on. And the file that disappeared is the first casualty. It won't be the last. Let's slow down for a second and talk about what a hearing on a gag order is supposed to look like in the state of Ohio. Because a lot of viewers, when they hear the word hearing, picture a big courtroom, a jury, lawyers in suits. That is not what we're talking about here. A gag order hearing is small. It is quick. It is often over in an hour. But it has one job. Its one job is to force the judge to say, on the record, in writing, why this order needs to exist. Not in general. In this case, with this defendant, with these facts. Now think about the timing. The July 14th order came down before any indictment, before a grand jury, before the case had really begun. That is a very early moment in a case to reach for the biggest silencing tool in the toolbox. And it is even earlier when you consider that Ohio law and federal law both prefer less restrictive alternatives, sequestering the jury, sealing specific documents, delaying certain filings. Those are all quieter tools that a judge can use before pulling the gag order lever. If Ron O'Brien is right that no hearing happened, then it is very possible those quieter tools were never even considered. And in the meantime, the file the jail deleted is still gone. I keep coming back to that. Because a booking video is not a state secret. A booking video is a routine business record created by a jail. Every county jail in Ohio creates one for every person who comes through their door. The reason those records exist is so that later, if there is a question about what condition a defendant was in when he arrived, a lawyer can go look at the tape. It is a check on power. It protects the defendant. It protects the jail. It protects the truth. When a jail sends a reporter a link to that record and then somebody inside that jail reaches up and pulls the link, that is not a small thing. That is somebody making a decision in the middle of the biggest case of their career that the public does not get to see what a routine business record shows. Not because the record is dangerous, because someone somewhere decided the timing was wrong. Who made that call? The jail's attorney will not say. He points at the gag order, but the gag order does not, on its face, cover routine jail records, which means the pointing is convenient. It is a shield. It is a way for the jail to hide behind a court order that maybe was not built to protect what they are using it to protect. That is the pattern the Columbus Dispatch is trying to break in court. Jack Greiner is not fighting for a headline. He is fighting for a principle, and the principle is old and simple and American. What the government has to be able to justify keeping from you, not the other way around. You do not have to justify wanting to see the booking video. The government has to justify hiding it. That is how it works. If you flip that principle around and make the citizen prove they need the record, you have quietly changed the country. And that is what a lot of the free press people in Ohio are worried about right now. Not just about this one case. About what happens the next time a rural county judge signs a piece of paper on a Tuesday afternoon without a hearing.